Assad. It's a pleasure to be here. I think I've been practically to every administrative body in the court in the state of New Mexico, but I've never appeared before all of them, so it's a pleasure to be here this morning. I am here representing Officer Woolever, and previous counsel was my former associate, Mr. King, Ian King. Ian King had represented Mr. Woolever, and up until yesterday, I had not been his attorney. As of yesterday afternoon, conversation and here today, I am officially his attorney from here on out. What I'd like to do is just briefly address this board and allow for Mr. Woolever to make a statement. What we're seeking today is the opportunity for Mr. Woolever to have his hearing. And what I believe due process requires is for Mr. Woolever to make his hearing. As you all know, there was, and you may not know, there was an attempt to, first there was a setting on July 18th sent out for a hearing that was scheduled for August 14th, 2013. There was a stipulated motion, stipulated by both parties agreeing, seeking Officer Lincoln allow for continuance in the matter. Despite the fact that there was a stipulated motion by both the parties asking for it to be continued, he denied the motion. And the reason for the continuance at the time was that Mr. Woolever was not able to come because he was in Texas, employed in Texas, unable to be here at that time because it would interfere with his ability to earn a living. So we sought a different date at that time and filed a secondary motion to reconsider timely and 2 weeks prior to the actual August 14th hearing date. It was also denied, and so since Officer Woolever was not, at the time was not going to be able to appear, I believe Mr. King and Mr. Woolever concluded that the hearing would be moot, and his inability to make a statement and appear at the hearing would render the hearing moot. So there was a notice of withdrawal of the request for a hearing. It was essentially, as I understand, speaking to Mr. Woolever yesterday afternoon. Fortunately, I apologize. I did not get in-depth discussions with Mr. King, who is no longer an associate. I think that's a good relationship with Mr. King. And I wanted to talk and tackle the issue of why strategically a notice of withdrawal of the request for the hearing was filed, rather than some alternative method to get Mr. Woolever his hearing. Nevertheless, in the body of the motion clearly indicates that they attempted. I recall Mr. Korn's questions to others this morning about whether they ever were given an alternative date, and unfortunately in this matter, there was attempts by the parties in the form of a stipulated motion to ask for that hearing, and both were denied. So it is somewhat of a procedural complexity that the withdrawal was filed, but I believe the board does have the authority, and if you don't feel that it does, maybe a better approach this afternoon would be to table the matter until I've had the benefit of researching a way to get Mr. Woolever here. But I think due process does require Mr. Woolever to have his hearing in a fair and impartial way to address what essentially is his future. So I find myself before you today with no further information as it pertains to the remedy and the request other than what I've stated to you previously. Like I said, I just spoke to Mr. Woolever yesterday. But I would like to have Mr. Woolever speak to you and then I'll answer any questions. Would that be okay, Mr. Korn?
As a procedural introduction, do you understand that our board is a little different when it comes to formal hearings than maybe courts are? A stipulated request from both parties for adjournment does not necessarily mean that the hearing officer will adjourn it. The board has made it very clear to every hearing officer that we want cases to be moved forthrightly, and delays that death or illness would be good excuses for delay, but that would be probably one of the few good excuses. So I should point that out to you, and I suspect was Mr. Woolever afforded the opportunity to appear by telephone from Texas?
No, Your Honor, I don't believe that from reading the motion, Judge, and from Mr. Horn, from reading the motion, I don't believe that that was afforded, but I don't know with certainty, and I cannot stand here before you tell you that I know for certainty that that wasn't afforded to us.
And Mr. Saad, just so you know, it would be the standard method of our board, especially hearing officers, to afford people the opportunity to appear if they're out of state by telephone. So it would be surprising if he wasn't afforded that.
I will tell you, if I may, Mr. Horn, members of the committee, I think that based on the nature of the evidence that was going to be presented at this hearing, and I would direct your attention to the synopsis having to do with Mr. Woolever, there was a clear indication that a video, enhanced video, would be part and parcel of the evidence that would be part of that hearing. And I find it very difficult for Mr. Woolever to be able to be effective in Texas on the phone with the idea that a video would play such an important part of this case, an important part evidentiary-wise of the hearing.
So his attorney would be local. Mr. Woolever would be on the phone.
I understand that, and at the end of the day, I honestly don't want to turn the argument that you could not have a hearing. But I think that in order for there to be no idea that due process was not afforded, I think that moving the date to something suitable is probably easier than trying to cope with the idea of a video being in Albuquerque, an attorney being in Albuquerque, and his client being in Texas, and trying to be effective.
Well, I don't presume to speak for the board. I mean, the board will make its own decisions. I just want to tell you that, you know, when cases are set, and this case has been delayed for quite some period of time, and it's set for a hearing that, you know, Mr. Woolever was afforded, you know, at times, I'm sure, as formal hearings go. And it's a normal process to afford people to appear by telephone. So
I take that statement with respect, Mr. Horn, but I will tell you what is contradicting that position, which I completely understand, is that you have Officer Doyle, who is a secondary individual here, whose case was indeterminately continued.
well, these things travel on different tracks, though.
But it's the same case, essentially, or I should say the same set of facts with regards to the case.
Yes, but Mr. Doyle's case and Mr. Woolever's case went through different hearing officers and different tracks. So what happens with one has no bearing on what happens with the other.
But a policy with one should be consistent with the policy of the other, despite the fact that one hearing officer is different than the other. All I'm saying is, if there's an urgency here with regards to the hearing, then it should be consistent because the set of facts are the same as it pertains to Officer Doyle in terms of the evidence, not in terms of the charges. So the bottom line is, I do understand that there's urgencies that need to be met in some cases. There's a trap that needs to be addressed. I understand there's the efficiency of moving forward cases are important. I understand all those, and by no means do I try to minimize the importance of moving the cases forward. There are other policies. All I'm saying is, based on the fact that this gentleman here was making a living out of state as a result of this case, and asking the court, asking the officer for continuance in the form of a stipulated motion, meaning both parties saw fit that it was a reasonable request, that it should have taken a little bit more consideration than denying even a motion to reconsider. Having said that, we find ourselves here at a point where a notice of withdrawal was filed, and it was done in speaking to Mr. Woolever as a result of in what he believes was essentially a duress motion, because he did not feel that there could be any adequacy or any justice done in his hearing without his physical appearance here. So what I would ask is for the board to do one of two things to that, either to decide on a recommendation to allow for Mr. Woolever to have his hearing, let due process be prevalent in that hearing, allow for him to be present, or the alternative is allow for me to table the matter and allow for me to do a little bit more research on a procedural mechanism that gets us there.
Okay.
That's what I'm asking.
And I know the board may have questions of you, but did you say you wanted Mr. Woolever to speak?
Just briefly, if I could.
Sure.
Thank you.
Mr. Woolever.
I'd like to thank everybody for allowing me to speak. I just had a few concerns throughout the process that brought me here. When I first notified that I had a certification hearing, I was somewhat shocked because I did have a stipulated agreement that my certification would be held in abeyance until my employment appeal had concluded. To this day, my employment appeal has not even started. The notice of hearing was filed less than 30 days from my hearing. I personally was not notified until approximately 14 days before the hearing was to be held. At that time, I was on vacation in Florida. For me to make it here, I would have had to drop my family off in Texas, drive immediately here. Problem is, I had to be back at work that day. And 8 hours on the phone there, still 8 hours here. It's still, I'm missing work. I might possibly lose my job. That's why I cannot make it here. That's why I was offered that, and I told him it's the same thing. I can't miss work. Other than that, I would like for it to be tabled as well, so we can discuss this in further, discuss these issues, and possibly get a hearing date that I can make it to. Thank you.
And these members of the board, any questions for either Mr. Asada or Mr. Woolever? Any member of the board? Anything else to add, Mr. Asada?
I have nothing further, other than just to reiterate that I'm new to the facts in their totality, so I'm just playing catch up as of yesterday afternoon. But I figured I would target the main issues and try to do that this morning.
Okay, and does the director have the file of the procedural items in regard to Mr. Woolever's case?
Yes, sir, we do. However, I do not have the video that's in this file. I don't know what the video is.
No, just the procedural, not
Yes,
the
sir.
evidence.
I do.
So you'd be able to present that, the chronology, are you prepared to present that to support understandings now, or
Yes, sir.
can you give us a chronology of Mr. Woolever's?
At this point in time, sir, can we take a few minutes?
I might ask our counsel. Mr. Reynolds, is this the sort of thing that we can discuss in our closed session? Or do we need to discuss that now? Mr. Jones obviously needs some time to refresh his recollection about the file.
I don't think there's any violation if the board reviews the file and it looks at the chronology when we discuss it in closed session.
In the closed session.
Yes.
So why don't we postpone this till our closed session, Mr. Assad? We'll go through the file with Director Jones, and we'll assure ourselves a due process to place if we decide to not accept your motion, or we'll decide that due process did not take place.
Very good. Thank you very much.
Thank you. Thank you, Mr. Ryan. Oh, are there any other questions?